All right, well, welcome everybody. My name is Jeff Hunt. Welcome to our distinguished lecture series. I'm going to pull this up here. Get all ready. Well, welcome everybody to our April 2021 Distinguished Lecture Series featuring the wonderful Ilya Shapiro on the topic Supreme Disorder, Judicial Nominations, and the Politics of America's Highest Court. My name is Jeff Hunt, and I have the wonderful privilege of serving as the director of the Centennial Institute at Colorado Christian University and co-chairman of the Western Conservative Summit, the country's largest annual gathering of conservatives in the Western United States. Be sure to save the date. We are already planning for this year's summit, which will be held June 18th and 19th, 2021, right here in Denver, Colorado. I want to take a moment and welcome the Federalist Society Colorado Lawyers Chapter. Thank you so much for joining us this evening. As we begin this evening, please welcome CCU students Daphne Seafelt and Damon Sider to lead us in prayer and the Pledge of Allegiance. We'll start with Daphne, who is coming up right now.
Dear God, thank you for allowing us to have this platform where we can learn about these big political issues. As we wrestle with how much power our government is taking, I pray that we would remember that you are the one with ultimate power, that no matter what goes on in our country, that you are the one who is in control and knows what is happening. I pray that we would be able to trust you, but that we would also learn how to be responsible citizens in this country and to learn about these big issues. So thank you for the Centennial Institute and their willingness to bring these issues to light. And I pray that it would be a great talk and very informative. Amen.
All right, Damon, lead us in the Pledge of Allegiance, please.
Great. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Great. Thank you so much, Daphne, and thank you, Damon. We're so grateful for our wonderful CCU students. These students are so talented, and God is preparing them to lead our community. So be sure to continue to follow them in their careers. They're just getting started, and they're going to make a wonderful difference in our world. We're so grateful to welcome Ilya Shapiro as our distinguished lecturer this evening. The Distinguished Lecturer Series, held by the Centennial Institute at Colorado Christian University, invites our world's top thinkers to address our students, faculty, and the general public each month. During the lecture, please feel free to ask questions via the YouTube chat feature, and we'll ask them of Mr. Shapiro at the end of the lecture. Tonight, Ilya Shapiro will speak on the issue, Supreme Disorder, Judicial Nominations, and the Politics of America's Highest Court. I can't think of a more timely issue to discuss. With the creation of President Biden's commission to study court packing and the introduction by Senate and House Democrats to add 4 new seats to the U.S. Supreme Court, we are honored to hear from our distinguished lecturer this evening. Ilya Shapiro is a vice president of the Cato Institute, director of the Robert A. Levy Center for Constitutional Studies, and publisher of the Cato Supreme Court Review. Before joining Cato, he was a special assistant advisor to the multinational force in Iraq on rule of law issues and practiced at Patton Boggs and Cleary Gottlieb. Shapiro is the author of Supreme Disorder, Judicial Nominations, and the Politics of America's Highest Court, co-author of Religious Liberties for Corporations, Hobby Lobby, the Affordable Care Act, and the Constitution, published in 2014, and editor of 11 volumes of the Cato Supreme Court Review from 2008 to 2018. He has contributed to a variety of academic and popular professional publications, including the Wall Street Journal, the Harvard Journal of Law and Public Policy, the Washington Post, the LA Times, USA Today, National Review, and Newsweek. He is regularly providing commentary for various media outlets, and is a legal consultant to CBS News, and once appeared on the Colbert Report. Ilya, we got to hear all about that. Shapiro has testified before Congress and state legislatures and has filed more than 400 amicus curiae, friend of the court briefs in the Supreme Court, including one that the Green Bag selected for its exemplary legal writing collection. He lectures regularly On behalf of the Federalist Society, woohoo, was an inaugural Washington Fellow at the National Review Institute and a Lincoln Fellow at the Claremont Institute, and has been an adjunct law professor at the George Washington University and University of Mississippi. He is also the chairman of the Board of Advisors of the Mississippi Justice Institute, a barrister in the Edward Koch Appellate Inn of Court, and a member of the Virginia Advisory Committee to the U.S. Commission on Civil Rights. In 2015, National Law Journal named him to its 40 under 40 list of rising stars. Before entering private practice, Shapiro clerked for Judge E. Grady Jolly of the U.S. Court of Appeals for the Fifth Circuit. He holds an AB from Princeton University, an MSc from London School of Economics, and a JD from the University of Chicago, where he became a Tony Patino Fellow. Ladies and gentlemen, please welcome Ilya Shapiro.
Thanks very much for that, Jeff. You could have just posted the link in the chat or in the email. I think you actually did put my bio in the emails that went out. Otherwise, you could have just announced my title and my Colbert appearance, which also contributed to my wife having gone out with me at first. But that's a story for another day. So thanks very much for having me. I see behind you, it looks cold. You told me there was an ice storm. In a normal year, I'd be out there with you and enjoying spring skiing and what have you, or extra winter skiing, whatever the case may be. Instead, my allergies are going crazy here in heavy pollen April in Northern Virginia. So if you hear me sniffling or sneezing, don't worry. I'm fully vaccinated. My whole family is. It is totally allergies. Not that you're going to catch anything over the internet yet that we know of. So anyway, yeah, this book really has had legs. It came out 4 days after Ruth Bader Ginsburg passed away, and obviously was being sold while the Barrett hearings were ongoing during the election. So my publisher was quite happy, but away we go. This issue is simply not going anywhere because, as I'll discuss, the Supreme Court is an important institution. And to really understand why, I wanted to go back to the very beginning of our republic and see what role politics has played. But I won't start right at the beginning. I'll mention that in a moment. I'll just take you back 60 years to begin. When Justice Charles Evan Whitaker retired in March 1962, after just over 5 years on the Supreme Court, John F. Kennedy had his first opportunity to shape the High Court. The youthful president selected a man of his own generation, Byron White. White had met JFK in England while on a Rhodes Scholarship, after having been runner-up for the Heisman Trophy and spending a year as the highest paid player in the NFL, and the two became fast friends. White was a vigorous 45 years old and serving as the Deputy Attorney General under Robert F. Kennedy. JFK formally nominated him April 3rd, 1962. 8 days later, he had his hearing, a quick 90 minutes, including introductions and supporting testimony from Bar Association officials. What questioning there was largely concerned the nominee's storied football career. Whizzer White, as he was known, was surely the last person to play a professional sport while attending Yale Law School. The Judiciary Committee unanimously approved him, and later that day, so did the whole Senate on a voice vote. Times have changed a little bit. The battle to confirm Brett Kavanaugh showed that the Supreme Court is now part of the same toxic cloud that envelops all of the nation's public discourse. Ironically, Kavanaugh was nominated in part because he was thought to be a safe pick. With a long public career that's been vetted numerous times, he was firmly part of the legal establishment, specifically its conservative mainstream, and has displayed a caginess that made some on the right, still make many on the right, worry that he's too much like John Roberts rather than Antonin Scalia or Clarence Thomas. As it turned out, of course, 11th hour sexual assault allegations transformed what was already a contentious process into a partisan Rorschach test. And all told, Kavanaugh faced a smear campaign unlike any seen since Robert Bork. Senate Democrats had warned President Reagan that nominating Bork would provoke a fight unlike any he had faced, even after Scalia had been confirmed unanimously the year before. That's an interesting vignette. In '86, the Republicans still controlled the Senate, and Scalia was put up at the same time as Bill Rehnquist was being elevated to be Chief Justice, and he took a lot of heat. There's a lot of speculation that if Scalia and Bork had been reversed, in 86, 87 that they both would have gone through. But anyway, on the very day that Reagan announced Bork as his pick, Senator Ted Kennedy went to the Senate floor to denounce Robert Bork's America, a parade of horribles of what would happen if Bork would be confirmed in kind of all walks of life. It went downhill from there as the brusque Bork with a brusque beard refused to adopt the now common strategy of talking a lot without saying much. A few years later, Ruth Bader Ginsburg refined that into a pincer movement, refusing to comment on specific fact patterns because they might come before the court, and then refusing to discuss general principles because a judge could deal in specifics only. Confirmation processes weren't always like this. The Senate didn't even hold public hearings on Supreme Court nominations until 1916, which was a tumultuous time with the first Jewish nominee, but also Louis Brandeis was a crusading progressive, very politically controversial. But even after he eventually was confirmed, it took more than 4 months, the longest of anyone. After that, one of his new colleagues, Charles Evans Hughes, resigned to run against the sitting president, Woodrow Wilson, in that fall's election. So if you think 2020, 2016 were big years in terms of the interrelationship of Supreme Court politics and the presidency or presidential election, I see that, and I'll raise you 1916. It wouldn't be until 1938, however, that a nominee testified at his own hearing. In 1916, it was thought too unseemly. And as I alluded, the part of Byron White's hearing in 1962, when the nominee himself testified, lasted less than 15 minutes. But while the confirmation process may not have always been the spectacle it is today, nominations to the highest court were often contentious political struggles. For the Republic's first century, confirmation battles, including withdrawn and postponed nominations, or those on which the Senate failed to act, so Merrick Garland was by no means unprecedented. These sorts of things were a fairly regular occurrence. George Washington himself had a Chief Justice nominee rejected by the Senate. John Rutledge, who had lost Federalist support for his opposition to the Jay Treaty. So again, all of this churning politics right from the beginning. James Madison, the father of the Constitution, had a nominee rejected. John Quincy Adams, who himself had declined a nomination from Madison. You had people decline nominations, even decline to serve after they'd be confirmed, because communications being what they were, if you had a quick confirmation, you might not hear for several days that you were nominated and confirmed. And in the early decades, why would you give up your prosperous legal practice in Boston or sitting on the Pennsylvania Supreme Court to go to the swamp and work in the basement of the Senate on not very important cases, which is sort of what it was. Plus circuit riding, you had to go to the far-flung states and help out the fledgling courts, literally by horse, sometimes without carriage. But anyway, John Quincy Adams had a nominee, quote, postponed indefinitely. What a great euphemism for Senate procedure, right? During the lame duck period after Andrew Jackson had stopped his bid for re-election. Jackson then had a nominee thwarted, but a change in Senate composition allowed Roger Taney to become Chief Justice a year later and eventually authored Dred Scott. John Tyler, who assumed the presidency in 1841 after the 1-month presidency of William Henry Harrison, remember, caught pneumonia at his very long inaugural address during a cold snap in Washington and died a month later. Anyway, Tyler, who sort of joined the ticket to balance it out, was a man without a party, never lived down his nickname of his accidency. And congressional Whigs disputed his legitimacy, and their policy disagreements extended to judicial nominations. Tyler actually made 9 nominations, including several people several times, before finally getting one person confirmed. Indeed, most 19th century presidents had trouble filling seats. Millard Fillmore was prevented from filling a vacancy that arose during his tenure, as was James Buchanan. Congress eliminated Supreme Court seats to stop Andrew Johnson from replacing the 2 justices who died during his presidency. It took Ulysses Grant 7 tries to fill 3 seats. And Grover Cleveland ran into senatorial traditions about seats reserved for certain states, which he only overcame by nominating a sitting senator. In the 20th century, Presidents Harding, Hoover, Eisenhower, Johnson, Nixon, and Reagan all had failed nominations. FDR never had anyone rejected, but his court packing plan was, both in Congress and at the polls. And we can talk more about that if you like, since that's, again, in the news. And LBJ's proposed elevation of Justice Abe Fortas in 1968 led to the only successful filibuster of a Supreme Court nominee, a bipartisan one over ethics concerns, which wasn't even a true filibuster because Fortas never had a majority of pledged votes. It's not that he was somewhere between 50 and 2/3 or 50 and 60. He never even had a majority. And then Douglas Ginsburg, who Reagan announced he was going to nominate after Bork was rejected, Ginsburg withdrew before his name could be sent to the Senate for having smoked marijuana with his law students. I consider Doug Ginsburg to be the last public casualty of the drug war. When you think about it, has any public official's career suffered in the last 30 years for revelations of drug use, or at least marijuana use? Then, of course, there's Merrick Garland, the first nomination the Senate allowed to expire since 1881. But then the last time a Senate controlled by the party opposite the president confirmed a nominee to a vacancy arising in a presidential election year was 1888. As we know now, Senate Majority Leader Mitch McConnell's gamble worked. Not only did it not hurt vulnerable senators running for re-election, but the vacancy held Republicans together and provided the margin for Donald Trump in key states. Trump then rewarded his electoral coalition with the nomination of Neil Gorsuch, who was confirmed only after the Senate decided on a party line vote to exercise the nuclear option and remove filibusters. Opportunities for obstruction have continued, pushed down to blue slips, cloture votes, and other arcane parliamentary procedures, even as control of the Senate remains by far the most important aspect of the whole endeavor. The elimination of the filibuster was the natural culmination of a tit-for-tat escalation by both parties. More significantly, by filibustering Gorsuch, Democrats destroyed their leverage over future, more consequential vacancies. Moderate Republican senators wouldn't have gone for a nuclear option to seat Kavanaugh in place of Anthony Kennedy, but they didn't face that dilemma. And they again didn't face it when President Trump got the chance to replace Justice Ginsburg so close to the election, which was an even bigger jurisprudential shift. Given the battles we saw over Gorsuch, Kavanaugh, and Barrett, too many people now think of the justices in partisan terms. That's too bad, but not a surprise when contrasting methods of interpretation now largely track identification with parties that are more ideologically sorted than ever. So why all the focus on one office, however high? If Secretary of State Mike Pompeo had died or resigned last year, it certainly would have been a big deal, but the slot would have been filled if someone with appropriate credentials were nominated. But of course, executive appointments expire at the end of the presidential term, while judicial appointments usually outlast any president. A president has few constitutional powers more important than appointing judges. Justice Scalia served nearly 30 years on the High Court, giving President Reagan's legal agenda a bridge to the 21st century. Same thing for Justice Ginsburg and President Clinton. 5 years ago, April 2016, there was a big ruling on nonprofit donor disclosures, an issue near and dear to the heart of both the Centennial Institute and Cato. Anyway, this was a ruling by a district judge appointed by Lyndon Johnson. For you students in the audience, that might as well be Andrew Johnson, right? Ancient history, but there for decades. Pundits always argue that judicial nominations should be among voters' primary considerations when choosing a president. Well, the Supreme Court's future truly did hang in the balance in 2016. The election was so consequential, in part because people knew that its winner would have the first chance in more than 25 years to shift the court's ideological balance. And that goes just as much, if not more, for the lower courts, which decide 50,000 cases annually, even as the Supreme Court hears fewer and fewer. Every 4-year term, the president appoints about a fifth of the judiciary. On Inauguration Day 2017, there were already 105 vacancies. That rose to more than 150 before a tweak in Senate debate rules sped up confirmations. Or to put it another way, when President Obama took office, only one of the 13 appellate circuit courts had a majority of judges appointed by Democratic presidents. After his 55 appointments, 9 did. Now, Trump partly reversed that, flipping 3 circuits and getting a record 30 circuit judges confirmed in his first 2 years, about the same number as Bush and Obama combined at that point in their presidencies. And 54 overall, better than anyone in one term except Jimmy Carter, for whom Congress created many new judgeships to fill as a sort of consolation for not having any high court vacancies on his watch. Even if politics has always been part of the process, and even if more justices were rejected in our country's first century than in its second, we still feel something is now different. Confirmation hearings are the only time that judges go toe-to-toe with politicians. And that's definitely a different gauntlet than even President Tyler's nominees ran. So is it all about TV and Twitter, the 24-hour news cycle and the viral video? Is it that legal issues have become more ideologically divisive? No, the nomination and confirmation process hasn't somehow changed beyond the framers' recognition. And political rhetoric was as nasty in 1821 as it is in 2021. If you Google election campaign ads, Jefferson Adams 1800, you'll find these very professional campaign ads, videos taken using language from pamphlets and speeches in that 1800 election. And it's just as much, if not more nasty than anything that we see now. All these parts of the current system that we don't like are symptoms of a much larger phenomenon. As government has grown, so have the laws that courts interpret and their reach over ever more of our lives. Senatorial brinksmanship is symptomatic of a larger problem that began long before Kavanaugh, Garland, Thomas, or even Bork. And that's the court's self-corruption, aiding and abetting the expansion of federal power, and then shifting of that power away from the people's elected legislative representatives and toward executive branch administrative agencies. The judiciary affects public policy more than it ever did. And those decisions increasingly turn on the party of the president who nominated the judge or justice. So as the courts play more of a role in the political process, of course, the judicial nomination and confirmation processes are going to be more fraught with partisan considerations. This wasn't as much of a problem when partisanship meant rewarding your cronies, but it's a modern phenomenon for our parties to be both ideologically sorted and polarized. And so, as I said, for judges nominated by presidents from different parties to have markedly different constitutional visions. Although the court is still respected more than most institutions, more than any governmental institution short of the military, it's increasingly viewed through a political lens. So what lessons can we draw from the sweep of confirmation battles? If you're taking notes, I have 7 lessons that I'm going to give you. First of all, politics has always been part of the process. From the beginning of the Republic, presidents have picked justices for reasons that include balancing regional interests, supporting policy priorities, and providing representation to key constituencies. Whether looking to candidates' partisan labels or so-called real politics, they've tried to find people in line with their own political thinking. Even in the earliest days, it was rare for someone to be on the Supreme Court shortlist of presidents from different parties. Look at the judicial battles of Adams and Jefferson with the Midnight Judges Act, the original court packing in 1800, as well as Jefferson's failed attempts to appoint justices to counter the great Federalist John Marshall. In the years that followed, when U.S. politics was defined by rivalries within the Democratic Republican Party and its successors, ambitious lawyers knew that their careers depended on navigating the intra-party split. There's never been a golden age when merit as an objective measure of brain power and legal acumen was the sole consideration. When those nominees got to the Senate, they faced another gauntlet, particularly when the president's party didn't have the majority. Historically, the Senate has confirmed fewer than 60% of Supreme Court nominees under divided government, as compared to about 90% when the president's party controls the Senate. And timing matters too. Over 80% of nominees in the first 3 years of a presidential term have been confirmed, but barely more than half in the fourth, meaning election year. And so when you have divided government in presidential election year, that doesn't bode well. So Merrick Garland was facing about a 20% chance just based on the historical record of being confirmed. As I said at the outset, nearly half the presidents have had at least one unsuccessful nomination, starting with Washington and running all the way through Barack Obama. Donald Trump avoided that fate, but he had 3 of the most contentious nominations in our history. In all, of 164 nominations formally sent to the Senate, only 127 were confirmed, a success rate of 77%. Of those 127, 1 died before taking office and 7 declined to serve, the last one in 1882. I don't think we're going to see that ever again. Of the rest, 12 were rejected, 12 were withdrawn, 10 expired without the Senate's taking any action, and 6 were postponed or tabled. In other words, fewer than 3/4 of nominees have ended up serving. Based on relative rates of unsuccessful nominations, the argument could be made that the nomination and confirmation process was actually more political during the nation's first century than since. Both the presidency and the court were relatively weak, and the process was more of an insider's game, with many picks based on personal loyalty and political philosophy rather than approach to the law. Of the 57 justices confirmed in the court's first 100 years, roughly 1789 to 1898, 17 lacked significant judicial experience. As the judiciary took on a greater role, however, nominations attracted more public attention and also more transparency. Interest groups began to matter, unions and the NAACP especially, as public relations became just as important as Senate relations. Politics came back into the process in a different way. The battle became one over ideology and public perception rather than satisfying intra-party or regional factions. Okay, point number two, or lesson number two. Confirmation fights are now driven by judicial philosophy. That's the way that politics plays a role now. As we've seen over the long sweep of American history, confirmation controversies are hardly unprecedented. To a certain extent, the politicization of Supreme Court appointments has tracked political divisions nationally. But the reasons for those controversies in the last few decades are largely unprecedented. While inter and intra-party politics have always played a role, couching opposition in terms of judicial philosophy is a relatively new phenomenon that represents a departure from the past. Pre-modern controversies tended to revolve around either the president's relationship with the Senate or deviations from shared understandings of the factors that go into nominations for particular seats, especially geography and patronage. That dynamic is markedly different from the ideological considerations we see now for at least two reasons. First, modern fights transcend any particular nominee or even president, evolving and growing and filtering into the lower courts. Second, ideological litmus tests cause more of a problem than the geographic, patronage, religious, and other past criteria. With the two major parties adopting essentially incompatible judicial philosophies, it's impossible for a president to find an uncontroversial nominee. The conservative legal movement, meanwhile, has learned its lesson. No more suitors means there has to be a proven record, not simply center-right views and affiliations, showing, not telling, a commitment to originalism and textualism. Once you consider someone who doesn't have a long judicial record, or at least academic writings to the same originalist textualist effect, it opens the door to the sort of unmoored presidential discretion that has led to so many misfires. The entire reason candidate Trump released his list was to convince Republicans, as well as cultural conservatives who may otherwise have stayed home or voted Democrat, that he could be trusted to appoint the right kind of judges. This was a real innovation, and we could see lists become standard practice, even if candidates from the two parties might use different criteria for shaping those lists, with more concern for demographic representation among the Democrats, who have a broader swath of lawyers to choose from. The current emphasis on judicial philosophy may be an updating of the, quote, real politics approach favored by presidents in the early 1900s. Teddy Roosevelt, William Howard Taft really patterned that, except now applied to intellectual commitments instead of trying to find or avoid progressive Republicans or conservative Democrats. Okay, lesson three. Confirmations are different now because political culture is different. The inflection point for our legal culture, as for our social and political culture, was 1968, which ended that 70-year near perfect run of nominations. Until that point, most justices were confirmed by voice vote without having to take a roll call. Since then, there hasn't been a single voice vote, not even for the 5 justices confirmed unanimously or the 4 whose no votes were in the single digits. And despite those easy confirmations, we've seen an upswing in no votes. 6 of the closest 9 confirmation margins have come in the last 30 years. Not surprisingly, the increased opposition and scrutiny has also signaled an increase in the time it takes to confirm a justice. 6 of the 8 longest confirmations, and all but 1 that took longer than 80 days, have come since 1986. Every confirmation since the mid-70s, except Sandra Day O'Connor and Ruth Bader Ginsburg, has taken more than 2 months. And now Amy Coney Barrett as well, because she was right before the election. There are many factors going into the contentiousness of the last half century. the Warren Court's activism and then Roe v. Wade, spawning a conservative reaction, the growth of presidential power to the point where the Senate felt the need to reassert itself, this culture of scandal and loss of institutional trust since Watergate, a desire for transparency when technology allows not just a 24-hour media cycle, but a constant and instant delivery of information and opinion, and fundamentally more divided government. As the Senate has grown deferential and presidential picks have become ideological, seeking to achieve a certain legal agenda or empower a certain kind of jurisprudence rather than merely appointing a good party man, the clashes have grown. And as these philosophical battle lines have hardened, so have the widespread media campaigns orchestrated by supporters and opponents of any given nominee. There's a straight line from the national TV ads against Bork to the tens of millions of dollars spent supporting and opposing Kavanaugh, including sophisticated targeting of digital media to voters in states where senators are the deciding votes. To put a finer point on it, all but one failed nomination since Fortas, since that pivotal year of 1968, have come when the opposite party controlled the Senate. The one exception is Harriet Miers, who withdrew because she was the first nominee since Harold Carswell in 1969 to be seen as not up to the task. The last nominee rejected by a Senate whose majority was the same party as the president was John Parker by 2 votes in 1930. For that matter, this turbulent modern period has seen few outright rejections. Nixon's 2 and Bork are the only ones in 53 years, with pre-nomination vetting and Senate consultation obviating most problematic picks. At the same time, the inability to object to qualifications has led to manufactured outrage and scandal mongering. This was more evident before considerations of judicial philosophy became standard practice when Bork was an outlier. Quote, many people sneer at the notion of litmus tests for purposes of judicial selection or confirmation, even as they unknowingly conduct such tests themselves. Harvard law professor Randall Kennedy wrote this more than 20 years ago. The real problem, as he saw it, was not that being able to discuss ideology led to a search for scandal. Quote, a transparent process in which ideological objections to judicial candidates are candidly voiced is a much needed antidote to the murky politics of personal destruction. Sounding the same refrain was one Chuck Schumer. Quote, the taboo on invoking ideology has led senators who oppose a nominee for ideological reasons to justify their opposition by finding non-ideological factors, like small financial improprieties from long ago. This gotcha politics has warped the confirmation process and harmed the Senate's reputation. Again, this is about 20 years ago. Well, that taboo no longer exists, which is an honest thing because vetting a nominee's judicial philosophy is important. And yet we still got the Kavanaugh hearings. So lesson 4, hearings have become kabuki theater. Public confirmation hearings have only been around for a century, starting, as I said, with Louis Brandeis's nomination in 1916. But Brandeis didn't testify at his own hearing. It simply wasn't regular practice until the 1950s, when the hearings became an opportunity for Dixiecrats, the Southern Democrats, to rail against Brown v. Board of Education and question nominees about civil rights. Few senators, other than the segregationists, even asked any questions. Otherwise, hearings became perfunctory discussions of personal biography, as with Charles Whitaker in 1957, or the man who succeeded him in 1962, Byron White. John Paul Stevens, the first nominee after Roe v. Wade, wasn't even asked about that case, if you can imagine. The focus in that post-Fortas, post-Watergate time was on ethics, and Stevens was confirmed 19 days after nomination. Things changed in the 1980s, not coincidentally when the hearings began to be televised. Here's a trivia question. The Bork hearings were actually the first ones to be televised gavel to gavel, not because the networks thought that this would be more controversial necessarily than previous hearings, but because 1987 was when C-SPAN got its license for full Senate coverage. It got its license for full House coverage in 81 or 82, and it didn't happen with the Senate till 87. So now all senators ask questions, especially about key controversies and fundamental issues, but nominees largely refuse to answer, creating what Professor Elena Kagan 25 years ago called a vapid and hollow charade. But even with this conventional narrative, there's still been a further subtle shift. From Robert Bork in 1987 through Stephen Breyer in 1994, nominees went into some detail about doctrine. That's not to say that during those years they made commitments about how they would rule on contested issues, but they did discuss their judicial philosophies, their past writings, their beliefs about the role of the judge. But beginning with John Roberts in 2005, they still covered the holdings of cases and what lawyers call black letter law, what you need to get a good grade in law school, but there's been little revelation of personal opinions. The nominees speak in platitudes. Roberts and his judicial umpire, Sotomayor saying that fidelity to the law was her only guidepost, Kagan accepting that we're all originalists now. President Trump's nominees were even hesitant to take a view on whether iconic cases like Brown were correctly decided, lest their inability to similarly approve of another longstanding precedent, Roe v. Wade, cast doubt on its validity. These days, senators try to get nominees to admit that certain controversial cases are settled law, whether Roe when coming from a Democrat or District of Columbia versus Heller, the Second Amendment case from a Republican. Of course, when you're dealing with the Supreme Court, law is settled until it isn't. So nominees have come to say that every ruling is due all the respect of a president of the Supreme Court or some such, which may or may not be a lot of respect, depending on the future justice's view of the merits and of the weight of stare decisis, the idea that some erroneous precedent should be allowed to stand to preserve stability in the law and protect reliance interests. And that's before we even get to the gotcha questions or last-minute accusations of sexual impropriety. Okay, the next lesson. Every nomination can have a significant impact. The actual hearings and the confirmation process more broadly have very little to do with being a judge or justice. Once that spectacle is over, the new justice takes his or her seat among new colleagues, a lifetime team of 9, as Justice Kavanaugh called it, to begin reading briefs and considering technical legal issues. It has to be a surreal experience, having run an American Ninja Warrior course to win a life of quiet contemplation and oracular pronouncements. Or, as President Trump's first White House counsel, Don McGahn, put it, it's a Hollywood addition to join a monastery. Regardless, once you're in, you're in. As Justice White told Justice Thomas, it doesn't matter how you got here. All that matters now is what you do here. After all the nomination hoopla, the Supreme Court is still a court, albeit with a new composition that affects both internal dynamics and external results. White was also fond of saying that every justice creates a new court. So each change shakes up the previous balance, regardless how close in expected philosophy a new justice might be to his or her predecessor. That's why every single vacancy is important. Not all historically significant cases would have turned out differently if a single justice were replaced. Marbury versus Madison and other Marshall Court cases were typically unanimous. Dred Scott was 7-2. Plessy versus Ferguson was 8-1. Korematsu, the Japanese internment case, was 6-3. Wickard versus Filburn, a controversial expansion of the federal government under the Commerce Clause, was unanimous, as was Brown v. Board. Roe v. Wade was 7-2. But anyway, some cases would have come out differently for replacing one justice, and not simply by changing the party of the president making the appointment. The slaughterhouse cases, which eviscerated the 14th Amendment's protections against state action, were a 5-4 ruling, with Lincoln appointees split 2-3, Grant appointees split 2-1, and a Buchanan appointee breaking the tie. Lochner versus New York, an important case in the early 20th century about the scope of potential state regulations against economic liberty, was also 5-4, with Republican appointees split 3-3 and Democratic appointees split 2-1. The early New Deal cases were typically split 6-3 or 5-4 against expansions of federal power, aligning the so-called four horsemen, 3 Republican appointees and a Woodrow Wilson appointee, James Clark McReynolds, against the 3 musketeers, 2 Republican appointees and the progressive Brandeis, with 2 other Republican appointees in the middle, culminating in 1937's switch in time that saved 9, when Owen Roberts, another Justice Roberts, started approving of expansive new federal programs. And all that's before we get to the modern era, when we got used to first Justices Stewart and Powell, then O'Connor and Kennedy as swing votes. So many cases would have been decided differently had the conservative Bork been confirmed instead of the moderate Kennedy, and differently still with the libertarian Douglas Ginsburg. For that matter, had Edith Jones been nominated in 1990 instead of David Souter, Kennedy wouldn't have been the median vote from 2005 to 2018. Roberts would have been. And if Michael Luttig had been picked instead of Roberts in 2005, it would have been a very different court these last 16 years. Moreover, court majorities are fragile and subject to affinities and clashes. Chief Justice Marshall drew people toward him who normally wouldn't agree with him. Justice McReynolds pushed everyone away. Justice Brennan was gregarious and a skilled tactician, often outmaneuvering Chief Justice Berger. Justice O'Connor may have shaded left in response to Justice Scalia's provocations, or to balance the arrival of the more conservative Justice Thomas. In part because they've been burned so many times, Republicans focus on the court as an election issue much more than Democrats. Bush v. Gore, Citizens United, and Shelby County, the three biggest progressive losses of the last 20 years, have riled activists and elites and ratcheted up confirmation battles, but haven't translated into campaigns regarding judges as such. Democrats may now be catching up, even though during the Garland experience, they didn't make much of the vacancy. The result of the 2016 election was that, for the first time in the modern era, and perhaps more clearly than ever, different judicial methodologies and approaches line up with partisan preferences. For the foreseeable future, then, every vacancy is an opportunity to either prolong one party's control of a particular seat or flip it. Another reason why filling each vacancy is such a big deal is that justices now serve longer. In the late 1700s, when life expectancy was under 40, skewed by infant mortality, of course, the average age of a nominee was about 50. In the late 1900s, early 2000s, when life expectancy is just under 80, more than that for those who are already in late middle age, the average age of a Supreme Court nominee is still not much above 50. And that includes the outlier Merrick Garland, who at 63 wouldn't have been picked had it not been for the unusual situation in which President Obama tried to offer a compromise. Since 1972, so the last 50 years, only one of 7 justices was over 55 at confirmation, and that's Ruth Bader Ginsburg. To put it another way, before 1970, the average tenure of a Supreme Court justice was less than 15 years. Since then, it's been more than 25. The life expectancy of justices once confirmed has grown from about 8 years at the beginning of the Republic to 25 or 30 today. Justices appointed at or before age 50, like Roberts, Kagan, Gorsuch, and Barrett, are likely to serve 35 years, projecting the legal policy impact of Presidents Bush, Obama, and Trump, respectively, as far into the future as Scalia and Kennedy did for President Reagan. Thomas, who was 43 when he joined the court and has already served 30 years, could serve another decade. Okay, lesson number 6. The hardest confirmations come when there's potential for a big shift. So in addition to divided government, at a time when the court's ideological profile is more clearly defined, the most contentious nominations are those that threaten a shift in the court's jurisprudence. Replacing the centrist Powell with the conservative Bork provoked a firestorm, but putting another moderate, Kennedy, in that seat was easy. Replacing liberal lion Thurgood Marshall with counterculture conservative Clarence Thomas was a fight, but appointing Scalia to William Rehnquist's seat when Rehnquist was elevated was a cakewalk. Would Kavanaugh have faced such strong opposition had he been nominated for Thomas's seat? Probably not. There are only 2 modern moves in a more liberal direction. The first was Ginsburg's replacement of Byron White, but that smooth confirmation came at a time when the Democrats had a significant Senate majority, 57 to 43. Newly elected Bill Clinton was enjoying his honeymoon, and White himself had been appointed by a Democratic president. The second was Merrick Garland's nomination to replace Scalia. Think of it this way. Regardless of which party controls the Senate, will there be a bigger political battle if President Biden gets to replace Justice Breyer or Thomas? Of course, presidents aren't always successful in moving the court in their preferred direction. Thomas Jefferson tried valiantly to dislodge the powerful Federalist judicial impulse, only to see his nominees fall under John Marshall's sway. Abraham Lincoln named Treasury Secretary Salmon P. Chase as Chief Justice, partly to get him out of his hair, but more importantly, to uphold the legislation by which the federal government had financed the Civil War and which Chase had helped draft. Instead, Chief Justice Chase wrote the opinion finding the Legal Tender Act, paper money, unconstitutional. Ulysses Grant wanted to mold the court for the post-Civil War world, but it took him 8 nominations to seat 4 justices of varying quality and political direction. Teddy Roosevelt should have been pleased with the great progressive Oliver Wendell Holmes, but after a vote in the major antitrust case of the time, Teddy Roosevelt's biggest issue, the president inveighed that, quote, "I could carve out of a banana a judge with more backbone than that." Woodrow Wilson named another storied progressive, Brandeis, as I mentioned, but also the most retrograde justice of that or possibly any time, McReynolds, who didn't seem to share any of Wilson's views other than with regard to antitrust and bigotry. Calvin Coolidge's sole nominee, Harlan F. Stone, would end up betraying his benefactor's laissez-faire proclivities by joining with Justices Holmes and Brandeis in taking the court in a judicially restrained and therefore progressive direction. Harry Truman called putting Tom Clark on the court his biggest mistake after Justice Clark ruled against his 1952 seizure of steel mills during the Korean War. Dwight Eisenhower was disappointed with both Earl Warren and Bill Brennan, although the latter was more of a political calculation ahead of the 1956 election, intended to help with the Catholic and crossover Democrat, therefore, vote, and it did. Eisenhower picked up support in the metropolitan Northeast that he didn't have in his first run. Nixon's appointment of Harry Blackmun similarly mitigated the reversal of the Warren court that he had hoped to achieve, particularly given that Warren Burger wasn't a particularly strong leader and Lewis Powell became more of a moderate. Ronald Reagan, too, advanced his own legal policy agenda only with Scalia. George H.W. Bush, of course, had Souter in addition to Thomas. His son, looking for reliable conservatives, checked that box with Roberts and Alito, but didn't realize that a focus on judicial restraint could also lead to unpleasant results. Moreover, a nominee picked for his views on the issues of the day, government expansion under FDR, executive power over national security under George W. Bush, might act contrary to type when the issue constellation changes. The judicial restraint of Felix Frankfurter, a New Deal progressive who co-founded the ACLU, made him a conservative in the post-war era, while John Roberts' similar restraint leads him to defer to both a wartime president and a peacetime Congress. Okay, final lesson, number 7. The court rules on so many controversies that political battles are unavoidable. Under the framers' constitution, by which the country lived for its first 150 years, the Supreme Court hardly ever had to curtail a federal law. If you read the congressional record of the 18th and 19th centuries, Congress debated whether particular legislation was constitutional, much more than whether it was a good idea. Debates focused on whether something was genuinely for the general welfare or whether it only served a parochial or regional interest. In 1887, Grover Cleveland vetoed an appropriation of $10,000 for seeds to Texas farmers who were suffering from a terrible drought because he could find no warrant for such appropriation in the Constitution. We also had a stable system of rights that went beyond those listed in the Bill of Rights. These rights were retained by the people under the Ninth Amendment. And similarly, the 10th Amendment was redundant of the whole structure of powers, which was based on the idea that we have a government of delegated and enumerated and therefore limited powers. Judges play bigger roles today. As the court has allowed the federal government to grow, so has its own power to police the programs its own jurisprudence enabled. In 1935, FDR wrote to the chairman of the House Ways and Means Committee, quote, "I hope your committee will not permit doubts as to constitutionality, however reasonable, to block the suggested legislation." In the 30s and 40s, we thus had the perverse expansion of the Commerce Clause with cases like NLRB versus Jones and Laughlin, Wickard versus Filburn, which gained renewed prominence in the constitutional debate over Obamacare. After the switch in time that saved 9 that I mentioned, when the court began approving grandiose legislation it had previously rejected, no federal legislation would be set aside as going beyond congressional power until 1995. We also had the flip side of the expansion of powers, the warping of rights. In 1938, the infamous footnote 4 in the Caroline Products case bifurcated our rights such that certain rights are more equal than others, in kind of an Animal Farm approach to the Constitution. So it's the New Deal court that politicized the Constitution and thus also the confirmation process by laying the foundation for judicial mischief of every stripe. The Warren Court picked up that baton by rewriting laws in areas that are best left to the political branches, micromanaging cultural disputes in a way that made the judges into philosopher kings, elevating and sharpening society's ideological tensions. In that light, modern confirmation battles are all part of and a logical response to political incentives, given judges' novel, expansive role. When judges act as super legislators, the media and the public want to scrutinize their ideology for that very reason. As Roger Pilon, who founded the center that I now head at Cato, wrote presciently in an op-ed in the Wall Street Journal more than 20 years ago. Typically op-eds have the shelf life of 24 hours or less, but this one is still discussed. He wrote, quote, "Because constitutional principles limiting federal power to enumerated ends have been ignored, the scope of federal power and the subjects open to federal concern are determined now by politics alone. Because the rights that would limit the exercise of that power are grounded increasingly not in the Constitution's first principles, but in the subjective understanding of judges about evolving social values, they too increasingly reflect the politics of the day." The ever-expanding size and scope of the federal government has increased the number and complexity of issues brought under Washington's control, while the collection of these new federal powers into the administrative state has transferred ultimate decision-making authority to the courts. The imbalance between the executive branch and Congress, especially the latter's abdication of its leading constitutional role by delegating what would otherwise be legislative responsibilities, has made the Supreme Court into the decider of both controversial social issues and complex policy disputes. Senator Ben Sasse, if you recall watching the Kavanaugh hearings, discussed this dynamic in his opening remarks there. In a nutshell, Congress doesn't complete its work so it can pass the political buck to a faceless bureaucracy and to a judiciary that ultimately has to evaluate if what these alphabet agencies come up with is within spitting distance of what the law allows. What's supposed to be the most democratically accountable branch has been punting its duties and avoiding hard choices since long before the current polarization. Gridlock is a feature of a legislative process that's meant to be hard by design, but compounded of late by citizens of all political views being fed up with a situation where nothing changes regardless of which party is elected. Washington's become a perpetual motion machine, and the courts are the only actors able to throw in an occasional monkey wrench. That's why people are concerned about the views of judicial nominees, and why we have the bizarre situation where there are more protests outside the Supreme Court than outside Congress. So is there anything we can do to fix this dynamic, to turn down the political heat on Supreme Court vacancies? Reform proposals abound. Term limits, changing the size of the court, not having permanent justices, but a rotating cast of circuit judges, setting new rules for the confirmation process, and more. I'm happy to discuss these in Q&A, and for that matter, the new Supreme Court Commission, which I recently wrote about in the Dispatch. I'll put that article in the chat. But anyway, all this reform talk really boils down to rearranging the deck chairs on the Titanic. And this Titanic is not the appointment process, but the ship of state. The fundamental problem we face is the politicization not of the process, but of the product. The only way judicial confirmations will be detoxified, the only way we reverse the trend whereby people increasingly see judges as Trump judges and Obama judges, is for the Supreme Court to restore our constitutional order by returning improperly amassed federal power while forcing Congress to legislate on the remaining truly national issues rather than letting bureaucratic rules govern us. John Maltese, a great scholar, wrote in his magisterial, The Selling of Supreme Court Nominees, a quarter century ago, quote, "Today's confirmation battles are no longer government affairs between the president and the Senate. They're public affairs open to a broad range of players. Thus, overt lobbying, public opinion polls, advertising campaigns, focus groups, and public appeals have all become a routine part of the process. Those trends have only accelerated in the intervening 25 years. Such that Supreme Court nominations are perhaps the highest profile set pieces in the American political system. Once the inside game of picking the nominee ends, the outside game begins, culminating in the literally made-for-TV hearing and then a vote that, as we learned with Justice Kavanaugh, can be just as dramatic. It's not good. But we've gotten here because Congress and the presidency have gradually taken more power for themselves, and the Supreme Court has allowed them to get away with it, aggrandizing itself in the process. So of course, confirmations are going to be fraught, particularly as I've mentioned now a couple of times, but I want to pound this home, competing interpretive theories mapping onto political parties that are more ideologically coherent than ever. There are two big buckets of cases where that dynamic has contributed to the ratcheting up of tensions that has crumbled Senate norms. First are cultural issues ranging from abortion and LGBTQ issues to the Second Amendment and the death penalty. And second, what I'll call size of government issues, everything from environmental regulations to Obamacare, guidance documents to enforcement practices. And then there's an overlay of structural cases, Bush v. Gore, Citizens United, Shelby County, partisan gerrymandering, whose legal issues in the abstract shouldn't have partisan valence, but in the real world, obviously they do. As the response of the conservative legal movement to various judicial provocations has shifted, the debate over that constellation of issues has crystallized. From calls for restraint in the face of the Warren courts making up social policy out of whole cloth, which ultimately led to too much deference to the political branches, the focus now is on engaging with the law, which often calls for invalidating the laws being reviewed rather than exercising what Alexander Bickel, a Yale law professor in mid-century, called the passive virtues. Indeed, activism has become a vacuous term that conveys nothing more than disagreement with the judge or justice or opinion being criticized. The battle has been joined over legal theory rather than judicial process. That is, so long as we accept that judicial review is appropriate in the first place, and how a judiciary is supposed to ensure that the government secures and protects our liberties without it is beyond me, then we should only be concerned that a court gets it right, regardless of whether that correct interpretation leads to a law being upheld or overturned. To paraphrase both John Roberts and Neil Gorsuch at their hearings, the little guy should win when he's in the right, and the big corporation should win when it's in the right. The dividing line then is not between judicial activism and restraint, but between legitimate judging and illegitimate judicial imperialism or abdication. It's a generational battle. Do you get into the fight over federalism and the separation of powers, or do you sit back and let the political branches handle that sort of thing, preferring not to mess up your judicial robes? And that gets us back to the debate over the administrative state, deference doctrines, congressional delegation of its own legislative powers, even more arcane areas of regulatory law, which is why, again, judicial selection has become so consequential. But the judicial debates we've seen the last few decades were never really about the nominees themselves, just like the proposals for court packing and the like aren't about good government. There's no platonic ideal number of justices. They're about the direction of the court. The left in particular needs its social and regulatory agendas as promulgated by the executive branch to get through the judiciary. That's why progressive forces pull out all the stops against originalist nominees who would enforce limits on federal power. Indeed, all of the big dust-ups in modern times have come with Republican nominees. The one quasi-exception didn't involve any attacks on the nominee, but the rare case of an election year vacancy under divided government. Merrick Garland would have been confirmed had Antonin Scalia died a year earlier. Not that any of this is a good thing. If nominations were depoliticized, whether through term limits or other reforms or some unpredictable shock that recalibrated norms, that would likewise depoliticize the exercise of judicial power, both in perception and reality. But term limits would take a constitutional amendment, and everything else is either unworkable or doesn't actually solve the identified problem. We can't just wave a magic wand and go back to some halcyon age where the issues we faced and the political dynamic were all different. The only lasting solution to what ails our body juridic is to return to the founders' constitution by rebalancing and devolving power, so Washington isn't making so many big decisions for the whole country. Depoliticizing the judiciary and toning down our confirmation process these are laudable goals, but that'll only happen when judges go back to judging rather than bending over backwards to ratify the constitutional abuses of the other branches. The judiciary needs to, once again, hold politicians and bureaucrats' feet to the constitutional fire by rejecting overly broad legislation of dubious constitutional warrant, thus curbing executive agency overreach and putting the ball back in Congress's court, and by returning power to the states and the people, while ensuring that majorities on the local level don't invade individual constitutional rights. After all, the separation of powers and federalism exists not as some dry exercise in Madisonian political theory, but as a means to that singular end of protecting our freedom. Ultimately, judicial power is not a means to an end, but an enforcement mechanism for the strictures of a founding document intended just as much to curtail the excesses of democracy as to empower its exercise. In a country ruled by law and not men, the proper response to an unpopular legal decision is to change the law or amend the Constitution. Any other method leads to a sort of judicial abdication and the loss of those very rights and liberties that can only be vindicated through the judicial process, or to government by black-robed philosopher kings. And as Justice Scalia liked to say, why would we choose 9 lawyers for that job? So the reason we have these heated court battles is that the federal government is simply making too many decisions at a national level for such a large, diverse, and pluralistic society. There's no more reason that there needs to be a one-size-fits-all healthcare system, for example, than that zoning laws be uniform in every city. Let federal legislators make the hard calls about truly national issues like defense or actually interstate actual commerce, but let states and localities make most of the decisions that affect our daily lives. Let Texas be Texas, California be California, Colorado be Colorado. That's the only way we're going to diffuse tensions in Washington, whether in the halls of Congress or in the marble palace of the highest court in the land. So thanks again for having me. I look forward to answering or dodging whatever questions you might have.
Preach, Brother Shapiro. That was wonderful. I was sitting here nodding along the whole time. And friends, you can see why I wanted to invite Mr. Shapiro to be a part of this evening's event. He just did a wonderful job laying out the importance of a limited government, separation of powers, and how a lot of the problems we're getting into now are a rejection of that. I also love, I encourage people to follow Ilya Shapiro, because I feel like you do a good job of calming everybody down. We oftentimes face these scenarios where people are panicking that, we've never seen anything like this in history. And here comes Ilya Shapiro with his wealth of knowledge when it comes to history, showing us that no, we have been here before and faced very similar things. We've got a number of questions here, everything around judicial reform, and then even justices avoiding topics. So why don't we talk about judicial reform, because it's up in the news now. Can you tell us what President Biden's commission is aiming to do, and then what the most recent proposals coming from both House and Senate Democrats with regards to new additional Supreme Court justices are? So can you give us kind of some background on what they're trying to achieve here?
Yeah. So ever since Garland, really, or I guess you could trace it back to Bush v. Gore, but Democratic elites, progressive elites, activists have felt that there are illegitimate justices on the court. Depending on who you ask, up to all 6 Republican appointees are illegitimate for one reason or another, whether it's blocking Garland or the fact that George W. Bush was only elected the first time because the Supreme Court selected him in Bush v. Gore, all of these various things. And so by the time the Democratic presidential primaries came around, and they started in 2019, all the various candidates were jumping on top of each other to propose different kinds of reforms to make the court more legitimate. And I have a chapter on this whole issue of legitimacy in my book, which really, the general public does not see the court as illegitimate. It sees Congress as illegitimate. It sees lots of things as kind of lacking confidence in, but the court is kind of a stabilizing factor. And sure, when there's a particular decision, either conservatives or liberals will be less confident in the court. But generally, the court is right now at a higher level of confidence than it's been in over a decade. So, but anyway, and ironically, again, during the Democratic presidential primaries, the two big candidates that were against court packing were Joe Biden and Bernie Sanders, the final two, as it were, the last men standing. This might be the only thing on which I agree with Senator Sanders on, and I'm not going to do the accent, but he was once asked, he's like, no, if we do that, the Republicans are going to do it when they're in power, and in 50 years, we're going to have 87 justices. That's crazy, right? Now, by the time it came to the general election, and Biden knew that the activists weren't particularly excited about his candidacy, they just knew that they wanted to get rid of Trump, but but that was it. He was more coy about court packing or anything else. And he said, yeah, the judiciary is out of whack, so I'm going to appoint one of these commissions. When do presidents historically appoint blue ribbon commissions? When they don't want to deal with an issue, when they want to kick a can down the road in hopes that whenever a report comes out, there's something else that's in the news, they can say, thank you, file it away, and nothing really happens. This commission in particular, I don't know if you followed the commentary about it, but both the left and the right is unhappy with this commission, which tells me that that might be a good thing. It might mean that nothing too crazy is going to come out of it. It has 36 people for one thing. I mean, I don't know, if people have served on committees before. If each person speaks for 5 minutes, that's 3 hours right there, not counting witnesses or whatever. So, this is very unwieldy. And with the exception of 2 retired judges or 3 very prominent progressive legal activists, the rest are professors, academics. So are they setting it up that whatever report comes out will just be dismissed as too theoretical, too nerdy, Anyway, so it's been attacked by progressive activists as not being too action-oriented enough. And its charge is to study all aspects of the court, not just whether the court should be expanded or that plus term limits or something. It's even like very nitty-gritty thing, like the process for taking up cases, or should the court's jurisdiction be expanded or contracted? What about, emergency appeals? All these very nerdy little technical procedural things on which maybe there could actually be more consensus than on some of the more, controversial structural things. I'm skeptical that something both uncontroversial and feasible without a constitutional amendment will come out of these recommendations. Although, I know most of the people on it. I'll probably be called to testify, so we'll see what happens. But term limits polls very well, and there could be consensus on that. But it would take a constitutional amendment. I'm not convinced by the very cute academic theories that you can just designate people as senior justices, because that's not maintaining the same office for good behavior for life as the Constitution requires. But B, term limits would prevent kind of political retirements and morbid health watches over octogenarian justices and kind of random vacancies, but it wouldn't change the ideological battle and significance of these seats that we've been discussing. So we'll see we'll see when the committee is supposed to come up with a report 6 months after its first hearing. Who knows when its first hearing is going to be? I wouldn't bet the committee report comes out before Christmas, if not significantly into the new year.
For them to add justices, 4 justices, would they need a constitutional amendment to do that, or can they?
No, that's a simple majority. Or you have to pass legislation, simple legislation. In the Senate, that's subject to filibuster, so they would have to change the rule to make it just a majority rather than 60. And Senators Manchin and Sinema, who are the deciding factors on this, have said that they're neither for court packing nor for eliminating the filibuster. So for now, something like that is not realistic.
Thank you. Ilya, question from the great and wonderful Will Trackman. Do you think the justices are avoiding hot button topics like election integrity and gun rights until things calm down a little and talk of court packing dissipates?
Yes. Next question. No, but seriously, just today, they denied cert in 3 very good cases involving potential restoration of Second Amendment rights for people with non-violent convictions, whether misdemeanor or felony, from like decades ago. So can you ever, is it constitutional for a state to forever deny someone their Second Amendment rights for having a non-violent conviction? And the court denied that. I mean, last term, they mooted out a case. They've had Second Amendment petitions challenging every different kind of regulation, and they have not acted. And similarly on election integrity stuff, I had thought that they would have taken up not one of the kind of Trumpian conspiracy theory type cases, but the case that actually presented itself before the election about the Pennsylvania Supreme Court unilaterally and seemingly against the Pennsylvania Constitution, rewriting election rules in various ways. What lawyers call the state legislature doctrine, because state legislatures are supposed to be the masters of state election laws. But neither ahead of the election nor after the election, when it was presented at a time where they could have taken it up without changing the results of the election or anything like that, but they did not take that up. So we'll see. There are other Second Amendment and abortion cases now pending. We'll see if they take any of that up. It takes 4 votes. I'll remind everyone who's not a lawyer. It takes 4 votes to take a case, to grant cert, what's called.
On that note, can we talk a little bit about John Roberts' role on the courts? You discuss him a little bit in your book, but your view of him, his transition during his time on the courts, how things have maybe changed under his watch. Can you share your perspective on that?
So John Roberts has not moved left or otherwise become more progressive in office. He's not trying to cater to the Georgetown cocktail party set. And by the way, that is such a tired trope that doesn't really exist, hasn't existed in 50 years. Like, I've been to a couple of Georgetown cocktail parties. It's not about that swaying someone or trying to get invited to some donor reception at the Four Seasons or something. I mean, it's just not a thing. But anyway, it's just that he is not an originalist. He is a minimalist. I mean, he's a conservative. He served in the Reagan administration. He's not some stealth candidate that's secretly to the left in some way, but he prizes minimalism, moving minutely, restraint, and tries valiantly to extricate the court from making political waves of any kind. Query how successful he's been in that. I mean, I think that the justices, and is notably him, because he's the one who's tacking in this kind of way, act least legitimately when they're concerned about things like legitimacy and other things other than just applying their own view of the law. So he finally got to be the median vote for 2 years after Kennedy's retirement, before Ginsburg's death. He was right in the middle of the court jurisprudentially. We haven't had a chief justice in the middle of the court in 50 years, and that was Earl Warren, where the court was not balanced 5-4. Warren, even though Warren was in the middle, he was not the deciding vote most of the time, and so he was really powerful in all sorts of ways, and unpredictable. Now that he's the 6th vote, it's a little different. But the dynamic is seen to relate back to the previous question, in which cases they decide to take up. So we have seen, because as I said, you need 4 votes to grant, which means even if Roberts doesn't want to grant, if the 4 of the more conservative justices want to, they will. But Kavanaugh, now looks like probably Barrett, are not as willing to do that with cases. And we've seen him on the losing side of 5-4 as well. So we'll see. This is coming up. This is the first June, the first end of term, when during that 2-week period they come up with all their biggest cases for the term. We'll see how all that breaks down. But very different being, you can see him being the 6th vote for conservatives much easier than you can see him being the 5th vote.
You mentioned the Warren Court. In your book, you talk about the Warren Court's kind of desire to take on structural injustices. I grew up attending public schools, and the Warren Court was often lauded as a great example of what the Supreme Court should be. And I think that still drives a lot of the liberals' kind of view of what the Supreme Court should be doing. Give folks kind of a review of the Warren Court and your critique of it. Sure.
This is in the 50s through Nixon's election. Earl Warren was appointed or nominated by Dwight Eisenhower because when Warren was governor of California, he critically threw his support behind Eisenhower in the 52 nomination process, and Ike rewarded him. And he ended up, spearheading all sorts of things, from desegregation and the civil rights revolution to a revolution in criminal procedure, to precursors to rulings on social issues, to the expansion of government, to government power in various ways. There were signs, especially in the Jim Crow South, to impeach Earl Warren as imposing federal power and judicial power on the states. But that's where the controversy was, and the reaction to that. And this is where I think was unfortunate, as I sort of alluded to in my remarks. The conservative reaction wasn't, "No, your theories are wrong. Here are better theories." Instead, it was, "You're being activist. judges should be restrained. Judges should sit on their hands rather than striking down all these laws, whether federal or state. You should just defer to the political branches. Well, deferring to the political branches means, it's a one-way ratchet for legislation. And if the legislature is to the left, it's going to be, progressive legislation. If to the right, it's going to be conservative legislation. But regardless, I think that's a breakdown in the judicial role. And it wasn't until the 80s where, the resurgence of originalism, and then especially the second wave of originalism, 15, 20 years ago, where you start talking about engagement and, fighting fire with fire rather than just sitting on your hands, that there's really a reaction to some of the expanses, both of the New Deal and the Warren courts.
You also discuss in your book a difference in judicial philosophy between Antonin Scalia and Clarence Thomas. Now, most conservatives would look at them and say, well, they're generally cut from the same cloth when it comes to their views of the courts and the Constitution, but you know that there is a difference in their judicial philosophy. Can you discuss that difference?
Scalia made his peace with the New Deal expansion of federal power. And you can see that in a case like Raich versus Gonzalez, a medical marijuana case out of California in 2005. So California had legalized as a state medical marijuana. In fact, it was the first state to do so in 1996. And a couple of women wanted to, who had cards, they were registered under the state for various medical conditions. They wanted to grow and consume their own marijuana. But they knew that federal law still does, makes marijuana completely illegal, including possession of it. And so they didn't want to, violate federal law, even if they were complying with state law. So they sued for a declaratory judgment to guarantee that the feds wouldn't come busting down their doors if they were just, not selling it, not traveling with it across state lines or anything, just growing, consuming it for their own medical purposes. And the Supreme Court ruled 6-3 that the federal law, the federal prohibition was okay. The majority, led by Justice Stevens and joined by Justice Kennedy, I should add, said because of the Interstate Commerce Clause, that growing and consuming marijuana is an economic activity that in the aggregate has an impact on interstate commerce, drawing on a case from 1942, Wickard versus Filburn, that I mentioned. So you went from, that case was about wheat regulations. You went from wheat to weed. But the sixth vote, I said that case was Raich was 6-3, was Scalia. He didn't agree with that expansive Commerce Clause analysis, but he referred to the necessary and proper clause. And he said sometimes it's necessary for the federal government to regulate even local activity in order to impose a national regulatory scheme. Thomas disagreed. The others who disagreed were Rehnquist and O'Connor. So that's on a substantive issue. And then also on kind of a procedural or doctrinal way, stare decisis, I mentioned, the idea that sometimes erroneous precedent should be preserved because getting them right will overturn too many social institutions, doing more harm than the error in the law way back when. That's the institutions have grown around did. Thomas basically has a very exceptionally weak view of stare decisis. I don't think he's ever met an erroneous precedent he wouldn't overturn. Scalia was much more cagey, and so did hew to stare decisis.
Ilya, let's do a rundown of the current justices. I think a lot of folks are looking at how Amy Coney Barrett's going to do, how Brett Kavanaugh's going to do. Conservatives were frustrated with Neil Gorsuch's decision with regards to, I believe it was, I don't think it was Title IX, I think it was Title VII. But perhaps you can.
That's really the only case. That's the Bostock case. I mean, it was a case of statutory interpretation. It wasn't a case of originalism or a constitutional interpretation. I think he got it wrong because he was too literal. He was looking to interpret the definition of the word sex and its connection to sexual orientation and gender identity, rather than the meaning of the phrase because of sex. Even in 2021, let alone 1964, you wouldn't say that if someone's fired for being gay that they were fired for because of sex. But anyway, that's really the only one. If you see so many other things, whether dissents from not taking up a Second Amendment case, whether cases about, I mentioned the delegation of legislative power by Congress improperly. Gorsuch has been railing about that. So he very often joins with Thomas in a whole lot of things, but conservatives obviously don't like the Bostock decision. Kavanaugh, it's still too soon to tell. He cited, in defense of religious liberty on these emergency applications, especially out of California during COVID, but those aren't, fully argued, fully developed cases. And he's only been on the court 3 years and kind of has been charting a middle path. There's not been deviations like Roberts, but he's typically not, there are plenty of cases where it's like Thomas and Gorsuch, sometimes with Alito on the right, Kavanaugh and Roberts in the middle, and then the progressives on the other side, that sort of thing. And Barrett, obviously, it's much too early because they haven't decided much this term yet.
Conservatives are watching one law very, very closely. Social conservatives are, in particular, the Equality Act. What are your thoughts on the pathway of that law? Is it likely to pass the Senate? And if it goes to the court, could it be challenged by the court? Religious freedom concerns about that law. Can you discuss the Equality Act?
Yeah, well, part of what the Equality Act did is supposed to do was already taken care of by Bostock, which is to extend employment discrimination protections to sexual orientation and gender identity. There are other things, and it's not clear, in what form it would pass. It has certainly stripped out religious liberty protections that were in place during other, earlier introductions of it, or similar type of legislation in places like Utah, where they extended protections but also maintained religious liberty protections and other things like that. It's Joe Manchin, West Virginia, that sort of legislation probably isn't too popular. So I don't think in the 50-50 Senate that's going to go very far. And you don't hear about it that much. You hear about HR 1, which is a series of mammoth reforms to voting regulation, campaign finance, things like that. You hear about the Green New Deal. You hear about court packing. The Equality Act seems to be on the back burner for now, but that could change. The Equality Act could, in theory, prevent decisions like the Jax Phillips case, Masterpiece Cake Shop out of Colorado. So it's if it were passed, I think there would be a lot of litigation about it.
In your career and in your book, you talk a little bit about taking on Obamacare. Can you help our audience understand your role with challenges towards Obamacare? Yeah, so
can't believe it's been over a decade now since President Obama signed the Affordable Care Act. I think it was March 30th, 2010, a day that will live in infamy. That was sued the same day, a couple of suits, one by Florida, one by Virginia, and away we went. And 2 years later, just over 2 years later, I was in the Supreme Court courtroom when John Roberts' red opinion was confused a lot of the news reporters trying to report on this, and they incorrectly reported that the Obamacare had been invalidated, where Roberts, on his own, read the individual mandate as a tax, or rather the penalty or the payment that one is required to make for not buying insurance to be a tax, and therefore authorized under the taxing power. It was a very high-speed litigation along the way. I helped coordinate various amicus briefs. I think there were 146 all told at the Supreme Court. I'm also, Randy Barnett and I, he was kind of like the intellectual godfather for the theory of why the individual mandate exceeded both the Commerce Clause and the Necessary and Proper Clause, which was the holding of the Supreme Court. But he and I are the only lawyers in the country who weren't representing the plaintiffs, the parties, to have attended all of the oral arguments in the various courts of appeal in Cincinnati and DC and Atlanta, and I forget there was one more. And so I was involved from I remember in the district court, when I was still in district court in Pensacola, Randy Barnett and I were on the phone I was in my office at Cato around midnight, and we were trying to develop the theory to challenge this on the fly. And at a certain point, we're like, this is good enough for district court. We'll do more ahead of the circuit. But that was a very interesting, and it was it was like a constitutional law course in a microcosm, because you had rights claims, you had structure claims, you had federalism, you had separation of powers, you had statutory law, you had different parts of constitutional law, all sorts of things. It was fascinating to watch. Ultimately, there were four separate issues, and the briefing was divided up into four separate issue areas. So I filed on all four of them, and on the meaty one about the individual mandate, I had 11 other organizations and 333. It just worked out to that neat number. State legislators joining my brief, and I tell you, in that courtroom, listening to John Roberts announce the decision, the scales fell from my eyes about him. My man crush on those baby blues just fell away, and also surprising was Anthony Kennedy. He read the dissent, or a summary of the dissent from the bench, which only happens when the dissenter is particularly passionate. So Ruth Bader Ginsburg, for example, read her dissent in Shelby County, and John Paul Stevens read his dissent in Citizens United, that sort of thing. But Kennedy was so passionate. I mean, it could have been Scalia. The passion that he had for federalism as a protector of liberty was really something to see. So that's the Obamacare story. Of course, 3 years later, the case would be back on the statutory issue about provision of subsidies to people buying insurance off exchanges established by the state, which John Roberts read to mean exchanges also established by the federal government. But that's another story.
Well, final question here for Ilya. In Neil Gorsuch's book, he seems to kind of rail against the Chevron decision. For those of us that aren't attorneys, and the role that it plays in expanding the executive, it seems like he's particularly passionate about returning to kind of the original intent of the Constitution when it comes to separation of powers. Do you see his leadership? Do you see the court, now that is a conservative majority, returning power back to the legislature, maybe even removing some of the power from the courts themselves, and trying to get back to a balanced notion of government?
Right. So first of all, I have to correct you on saying original intent. I don't care about original intent. I don't care what James Madison thought or would have thought about violent video games, right? It's the original public meaning of the words on the text. Different framers might have different intents for this or that, but what does unreasonable search and seizure in the Fourth Amendment, what does that mean in 1791? What does interstate commerce mean in 1789? What does due process of law mean in 1868? Because you have to do originalism at the right time. But anyway, so Chevron, this is one of the larger series of things I alluded to in my remarks called deference doctrines. That is, how much should courts defer to executive administrative agencies which are interpreting the laws that Congress passes? So the EPA applies the Clean Air Act, the Clean Water Act, but Congress didn't legislate every jot and tittle. The agencies fill in the gaps, basically. How much should courts defer to those interpretations? If it's an interpretation of an agency application of its operative statute, that's called Chevron deference, where under this case from the 80s, Chevron, courts will defer unless the agency's interpretation is, quote, arbitrary and capricious. So it doesn't have to be the absolutely right interpretation, but it can't be crazy. Okay. Then there's a different kind of deference where the agency maybe takes an interpretation, issues a regulation, but then 10 years later decides to apply its own regulation in a different way. How much should courts defer to that? And that's called AUER, AUER, or as was decided a couple of years ago in a case that completely shifted it. Now it's called Kaiser, K-I-S-O-R, thinly sliced Kaiser roll you can think of. So courts are deferring slightly less to agencies when they're doing that. But you're right. Both Gorsuch and Kavanaugh on the circuit courts were famous, made a name for themselves for pushing back on the power of the administrative state. And Gorsuch has had a number of opinions in that way. We'll see when the right case presents itself to reconsider those kinds of doctrines. It's not going to be on some hot button political issue. It's going to be on some very technical, boring bankruptcy case or something that they'll stake out the new way that courts are supposed to deal with agencies. But by the way, this is not supposed to be an ideological matter. Chevron itself dealt with the frustrations of the Reagan administration, whose deregulatory initiatives were stymied by the then left-leaning, as it is now, DC Circuit. So they were arguing for the DC Circuit to defer to the agencies. 30 years later, it's Dick Durbin and Dianne Feinstein getting upset with Neil Gorsuch at his hearing for not deferring to the agencies. Why they wanted Rick Perry and Betsy DeVos to have all this power, I don't know, but that's what they're saying. So anyway, this is not meant to be an ideological thing. It's meant to be a structural thing, separation of powers, checks and balances.
Ilya, you've been wonderful today. Thank you so much. Reading your book, and friends, I encourage you to go purchase it on Amazon while we still can.
I put a link in the chat. If you're not on the chat, you can just go to supremedisorder.com. And if you don't like Amazon, you can buy it at an independent bookstore, Barnes and Noble, all these other options. But also, wait, there's more. You can download for free a 20-page statistical appendix, historical appendix of all the nominations divided by party, who controlled government, cloture votes. And anyway, you're going to make yourself really popular at your next virtual or in-person cocktail party.
Well, and on that note, we've got a lot of students watching today. Final remarks for young, eager minds still in their undergraduate, maybe possibly thinking about following in your footsteps. Don't
go to law school. Go do something productive with your life. It's kind of like I kind of say it to the old story about the rabbi's advice to someone who wants to convert to Judaism. And with a name like Shapiro, I can make this joke, but the old rabbi kept saying no and no and no, and finally after the third time said, "All right, let's go talk about this." So you really have to have a good reason and a real plan for why you're going to law school. A default, or I want to save the world or something, that's not good enough, because there's a lot of unhappy and especially heavily indebted lawyers out there. So think about that. I'm happy to provide advice if you want to drop me a line. But if you think, well, Shapiro there has a great job, I want to do that, I'm like, yeah, I'm one of the exceptions. A lot of people going to law school wanted to do constitutional law. Now there are more of those jobs now than there was when I was starting in law school 20 years ago, but still it's hard to get into. Well, thank you again, Ilya Shapiro. We really appreciate it. How can people follow you on Twitter? I'm at iShapiro, and my email is ishapiro@cato.org. But thank you so much for having me, Jeff. And to paraphrase the old Passover blessing, next year in person. Amen. I like that. Friends, if you'd like to be part of conversations like these regularly, interact with conservative scholars, and take the next step for your future, be sure to check out Colorado Christian University by visiting ccu.edu. That's ccu.edu. Our next event will be the Western Conservative Summit, June 18th and 19th here in Denver, Colorado. Visit westernconservativesummit.com for more information. Thank you all for joining us. God bless you all.